night on the CINA 102.3 app at CINAFM.com, on TuneIn, on smart speaker, and at 102.3 FM. CINA Radio, every device, everywhere. The following program does not necessarily reflect the opinions of the management, staff, or advertisers of CINA Radio.
Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me, fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات، مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس، يأتيكم الآن على الهواء مباشرة. كما تعودتم مستمعينا دائما المعلومات القيمة في مختلف الاختصاصات من مكاتب المحامية جومانا كيروز التي تستقبل قضاياكم المتعلقة بالبيرسونال انجريز، كار اكسيدنتس، قضايا الهجرة والتجنس، قضايا الإفلاس والكريمنال لو، فاميلي لو، سوشيال سيكوريتي، وقضايا إصابات العمل، مع محامين متخصصين بهذه المجالات. للاستشارات المجانية دائما بإمكانكم الاتصال على الرقم 248-557-3645. حلقات برنامج يورايز تعاد مرة أخرى على الموقع الإلكتروني yourice.com/radio أو على اليوتيوب. كل ما عليكم والبحث عن قناة جومانا كيروز. ودائما حلقات المخصصة لقضايا الهجرة والتجنس كل يوم اثنين يعاد بثها مرة أخرى على راديو سينا يوم الأحد في تمام 7 مساء. تحياتنا لكم. أهلا جومانا وأهلا وسهلا فيك في راديو سينا.
صباح الخير رامي.
نور.
صباح الخير للمستمعين. صباح الخير للمحامي مايكل روث. Hello, attorney Michael Roth. Nice to see you again 2 weeks in a row. To remind the listeners that attorney Michael Roth heads the Social Security Benefits and Workmen's Compensation Department in our office with 31 years of experience. I see you busy all the time, meeting with clients all the time. We started last week by wanting to talk about injuries on the job, also called workmen's compensation, also called workers' compensation.
Yes.
And we did not say a word about workmen's compensation. You were itching to share some information. Oh. So we're going to give you the floor today. But a work-related injury is less likely than a social security, disability. And so I know that many more people are interested in listening about SSI and SSD than about work-related injury. Having said that, let me ask you a couple of questions, and please free to share what you want to share beyond those questions. A lot of people think that for an injury to be called work-related injury or a workman's comp injury, workman's comp is short for compensation, workman's compensation injury. It has to happen within the 4 walls of your job. True or wrong? True or false?
False.
False.
Yes.
Okay. So for an injury to be called a work-related injury, it has to be related to the scope of your duties on the job.
Mm-hmm.
That can be within the 4 walls of the job. That can be en route somewhere else. That can be in another place because you are fulfilling the scope of your duties. So if God forbid I ask one of my employees to go to the bank, drive their car, and go to the bank to deposit checks on my behalf, God forbid if they get into a car accident, is that a workman's compensation case?
Yes, providing they don't stray or deviate, that's a workers' compensation case.
Providing they don't go on a joyride, do their own thing. But if they were en route from the office to the post office or to the bank at my request or on my assumption or something like that, and they are injured, this is a workman's compensation injury.
Yes, it is.
It's also a car accident.
Yes, it is.
So in that case, they have benefits from an insurance company. They may have benefits from the other car if the other car hit them. They also have benefits from another insurance company. That's the insurance company for the employer, for medical treatment, for wages. Can you be a 1099 and suffer a work-related injury?
Well, the first answer would be no.
Yes.
Because you're an independent contractor and you are not an employee. So I would say no, except many situations are arising these days where the employer insists on characterizing its employees as independent contractors.
And we know why.
Oh, of course, you don't have to worry about any workers' compensation
FICA.
claims or, taking money out of their
Or paying
checks.
them health insurance. So
Right.
forget, some employers pay health insurance, some employers don't. Putting that aside for a minute. If you are an employee, then your employer must. Otherwise, your employer is violating tax laws. Your employer must pay on you and withhold from your check Social Security, workman's compensation, Medicare, Medicaid, unemployment. I don't know if I'm missing anything.
Well, I mean, they're going to hold out also your contributions to the Social Security retirement or Social Security disability.
Thank you very much. So, if your employer pays you $20 an hour, you're not going to net $20 because your employer will contribute and you will contribute this much percentage out of the $20 because that's how the federal government feeds the Social Security Administration. That's how the government feeds Medicare. That's how, in part, at least, the government feeds Medicaid. It's me, it's you, it's Rami, it's all of us who are working in an employee-employer. We are withholding some of our money
That's right.
to contribute for the welfare of everyone who needs Medicaid, who needs Medicare, who needs unemployment, who is on unemployment and is getting paid by the state, who needs whatever the case may be, federal benefits. It's what I'm contributing, it's what you're contributing, it's what he's contributing, it's what they're contributing. So an employer also has to pay her or his share. That is why a lot of employers want to call their employee an independent contractor because then they can avoid paying Medicaid, Medicare, and their contribution, their portion of FICA. So employers like to do that. That is illegal. That is a tax violation. That is also a state of Michigan tax violation. It's a Michigan state violation and it's a federal IRS violation. And the employers get to save money.
It's a misdemeanor under the Workers' Compensation Act.
It's a misdemeanor on the part of the employer.
That's right.
And also the IRS, you can be in very big trouble with the IRS and with the state of Michigan as well, Treasury Department. If you walk like a duck and you quack like a duck, I can call you a fish, but you really are a duck.
That's right.
So I can call you not an employee because I want to save paying FICA and maybe save you, but mostly save me as an employer. But if I have expectations of you, if I have set hours for you, if I tell you what you need to do, if I have a measure of control over you, if it matters where you do your job, remotely or not, it's a combination of things. When I have this much control over what you can and cannot do, when and where and so forth, I'm really an employer. I may call myself an independent contractor, but truth is, I am an employer. That means whatever I pay you, I'd better be holding my FICA portion. I'd better be holding your FICA portion.
Mm-hmm.
Okay. When we talk about workman's compensation, we're only talking about injuries in the context of an employer-employee. So we're talking about a W-2 person, not a 1099 person.
That's right.
Okay. So just to clarify, we did this roundabout way in the community at large that we serve. This issue of, let me call you a 1099, arises more often than you think.
It's certainly in hairstyling salons, it seems to be epidemic. And truckers these days, over-the-road truckers, are being pushed into having to have 1099 status versus the actual employee-employer relationship.
And again, if they are truly an independent contractor, if they set their hours, if they have a lot of control over what they're doing, yes, they are independent contractors. But just because you want to call somebody an independent contractor does not make him or her so.
No.
Just because you don't want to call somebody an employee does not make him not an employee. Because the law will apply these criteria. If you have control over someone and their time and what they're doing and where and how, call it whatever you want. You really are their employer. Now, going back to work-related injuries or workman's compensation or workers' comp, we're only talking about injuries to employees,
Right.
not to independent contractors.
Correct.
If I hire someone to do work on my home and I don't know, as they're going, they left the house because they need something and they went to Lowe's to pick up that item, come back to the house. And if God forbid they are in an injury, they're not my employee.
No.
They're really an independent contractor hired for this specific goal, for a limited goal, do this. I don't care who you bring with you, how you oversee it, when you come, when you leave. I don't have control over that. God forbid if they're in a car accident, that's not a workman's compensation. Because I'm not their employer. Maybe somebody else is their employer.
Right.
Thank
exactly.
you. Maybe
exactly.
they work for someone who's their employer, who puts them out there to do jobs. But vis-a-vis me, that person is not my employee.
And that's important that you bring that up, because even if a person is an independent contractor and then they hire others under them to do work for another person, if the person who's contracting has no workers' compensation insurance, the other person will basically be obligated to pay any benefits if that person gets injured. It's called a shoot-through provision. And
shoot-through provision. How do you write that, please?
SHOOT-THROUGH. Provision.
Okay.
And
can you paraphrase again what that means?
I hopefully I can do it a little bit better. Let's say
by the way, I want to apologize to the listeners that this is the second time we talk in English without even much of an attempt to translate into Arabic. So much information, struggling to understand myself, that it's going to be very hard to translate. We're shooting a lot of small information. It's hard to make translation on all of these issues.
But it's important to you because many of you have these kind of jobs and you really need to know about the rights you have when you're injured. So let's say you are, excuse me.
If I bring a contractor to my home,
right?
As to him, I'm not his employer.
Right.
I'm going to 1099 him at the end of the year, because anyone you pay more than $600 a year, you have to send them a 1099.
Okay. So if I am that independent contractor and I have hired or even have just subcontracted with other
part of the work you do
individuals.
for me
Right.
with others.
Well, right. I wouldn't use you as the example as the homeowner.
Okay.
I would use another bigger company.
Okay.
So suppose it's a general contractor.
Okay.
Suppose it's a company that's in charge of building the whole structure. And I have brought a number of men on board, or a number of men and women on board, to, let's say, do the rough carpentry or, hanging the drywall. And then one of these people get injured. If I, who have hired these individuals, do not have insurance, they are going to be able to go against the general contractor. Okay?
Mm-hmm.
And the general contractor will be obligated to take care of their workers' compensation benefits if they have any needs. But,
as if they were their employees.
Exactly. But the general contractor can go against the smaller subcontractor for reimbursement.
Okay. So as to the world, the general contractor has to take care of those people contracted via the subcontractor.
Correct.
Once the general contractor takes care of the physical and financial needs, income needs of these people under workman's comp,
And medical.
then he or she can turn back to the general contractor to make himself or herself whole.
Well, turn to the subcontractor to be reimbursed.
Because the subcontractor did not do what the subcontractor needed to do, which is purchase insurance.
That's right.
Not workman's comp insurance, because those people hired under the subcontractor were not his employees.
Sometimes they are, sometimes they're not.
Okay.
Regardless.
Regardless, even if they're not.
Right.
Okay. This is a lot like the duty of an employer vis-a-vis the world. An employer is vicariously liable for the acts and omissions of his employee.
That's right.
If, God forbid, you make a mistake vis-a-vis the world, although it's your mistake, but I am your employer, so I have to take on the responsibility of that mistake, and I have to make it right with somebody outside.
That's right.
Okay.
And the same with agents as well, which is what the subcontractor would be as well.
The subcontractor is an agent.
That's right.
Okay. So...
And it makes sense because the general contractor isn't going to have an expertise in hiring, carpenters, rough carpenters or finish carpenters, or for that matter, electricians.
So it makes sense that
that's right.
He should buy insurance, and if not, he is on the hook because he brought all these people.
Right. But he can't personally either supervise it. That's right.
Okay.
So he has to have that workers' compensation insurance.
It happens a lot if you're building, say, a restaurant.
Mm-hmm.
You have the general contractor, then you have the person who does the tile, and the person who builds the kitchen, and the person who does the lighting and the electrical, and and all of these people are brought under the general contractor.
Right.
And the general contractor does not have the expertise even to supervise.
That's right. That's
okay.
right. And if I could just leave one little message, please don't worry about whether or not you are an independent contractor or an employee. If they have told you, and you've been working under a subcontractor or under a bigger project, if they've told you, we're sorry, we don't have any workers' compensation benefits for you, again, your best bet is to talk to an attorney to find out if you in fact have that insured status.
Meaning the shoot-through. You can get coverage through the shoot-through provision.
That's right. And there's ways that you can check out to see if an employer has workers' compensation insurance.
You just took the words out of my mouth.
I'm sorry.
No, thank you.
Okay.
How does one... I see it within the context of people who work for medical transportation vans.
Mm-hmm.
They want to make a living, and they work for an employer who owns these vans. They are on the road. Their life is at issue at any one moment in time. And sometimes they discover the hard way that their employer, after an accident happened, did not have workman's compensation.
Mm-hmm.
So I have been asked that question, how do I know in those high-risk jobs at least, where there is a higher likelihood of an injury, how do I know before I take on a job if I am an employee, my employer is paying me W-2s, because the law says, let's backtrack and say, we were just talking about who is considered an employee and who is an independent contractor. Because again, in our community, a lot of employers want to call people under them contractors, not employees, because they save a whole bunch of money. It's illegal, and it can be a big Treasury issue and an IRS issue. Putting that aside for a minute, the law also says that when you are an employer, is it with 2 or more employees or 3 or more? You have to buy workman's compensation insurance for the protection of your employees, right?
Yes.
Okay.
It's 2 or 3.
Okay.
2 or 3, depending on how many hours.
Status, yeah,
That's right.
part-time. You're right about that.
How many hours, and
Yes.
then not just how many hours, how many weeks. And
okay.
you could
Isn't
read
that
my
lovely?
blog.
Just to make it... Oh, did you just write a blog about that on our website? Okay. So that... Right, as if it's not complicated enough. Okay, now we have to figure out how many. But the general rule is that when you are an employer with like 2 employees or more, under the law says, you know how the law says? If you have a car, in the state of Michigan at least, you need to purchase insurance on the car. The law also says that if you are an employer of 2 or more employees, you have a duty to buy workman's compensation insurance to protect your employees. Is everyone following that rule? Absolutely not.
No, they're not.
And again, I've seen it quite often. I've seen it in the context of people who are employed by medical transportation company in the risky business of transporting people and driving all day long. And lo and behold, they may be employees, they may be getting a W-2, but their employer did not buy workman's compensation insurance for the protection of these drivers. And the question arises, how do I know before I take a job if my employer, other than asking him or even looking like I'm looking for trouble or I am litigious and I want to sue, how do I find out if my employer has workman's compensation for my protection if I were in a car accident? You can call the state of Michigan and you can give that name and you can ask them if this person carries workman's compensation insurance. I have done it more than one occasion. The only thing is, Attorney Michael Roth, is if the employer chooses to stop paying the insurance, you won't know. So you can only call before you take a job because it's a risky job.
There's also a website. Yes. Workers' Compensation Agency will have a checkable list of people who are either insured or are self-insured, and you can put your employer's name into it. And if you have the right name, and sometimes you'll never know who you're really being employed by, if you have the right name, it will show whether or not they're insured and who insures them.
Because sometimes the legal name is different than the name
on your check.
Right.
Or sometimes they will hire a company to do your payroll, and you think you're working for that payroll company. So it can be very confusing.
It can be confusing. Yes, indeed. So we are talking about injuries.
Yes.
25 minutes later, we can conclude that we know the difference between who's an employee and who's an independent contractor, that workman's compensation only applies when you are an employee and your employer bought workman's compensation insurance. We also determined that in a workman's compensation setting, sometimes the injury happens outside the four walls of your job.
Very often.
But it may still be very often.
Yeah.
Give us example of some of those where it happens outside the four walls.
The comical ones? or
Comical ones, all of them. Make us laugh, please.
Okay, well, I guess if you want to test drive your pal's motorcycle after hours in the parking lot, you're actually engaged. You're not engaged in work activity, but because it's so close in time to either coming or going, that it's actually qualified as a compensable injury, believe it or not. Okay. On the other hand, if you're engaged in social and recreational activities, like smoking a cigarette during break, then it's not going to be compensable. So the general rule is, if you're on break or you're engaging in, if you're on break, it's usually not going to be compensable. But going to or coming from your break and you're injured, it may be compensable. Of course, if you're going to come back to work by sliding on the handrail of the stairs, that's not compensable. Let's see.
What about going to and going from work, workplace?
Usually, if you're in a parking lot that's either owned, maintained, or leased by your employer, and an injury occurs, you're going to be covered for your injuries under the Workers' Disability Compensation Act.
So let me make sure I understand. If the employer owns the building and the parking structure below, and an injury happens, maybe a slip and fall, that's a work-related injury. How is that related to the scope of the employment? Is it because you needed to get to your car?
Well, the statute says that for a period of time, both before your shift begins and after your shift begins, you can still be covered.
After your shift ends.
Yeah, I'm sorry. After your shift ends, you could still be covered. And it's not just the slips and falls. If you are assaulted in this parking lot, you would also be compensated. There are cases where women were assaulted and they were work-related injuries and they were covered under the Act.
They were compensated for their medical treatment and their wages.
Yeah, they were covered for, yeah.
But let's clarify. The law, it's a public policy whereby the law said you cannot sue your employer for your emotional pain and mental distress.
That's correct.
Let's be very clear.
Sure.
When you are in a work-related injury, whether it's the result of, ending a break or slip and fall in the parking structure or getting assaulted as you're entering your car, God forbid, you cannot sue your employer for mental suffering and anguish. The law of workman's compensation says when you are in a work-related injury, we don't want you to be suing your employers because society can't function. Just like public policy says, you can't sue your president and your senators for anything and everything. Generally speaking, there is immunity. So it's a little bit the same. For the general working of society, we can't have every employee sue their employer for their pain and suffering because of a work-related injury. Instead, we ask the employer to buy workman's compensation, and when an injury occurs, here is what the employee can get only. And listen to what I'm about to say, because nowhere in it does it say, like in a car accident, you can get, pain and suffering. That does not exist. You cannot sue your employer for your mental suffering and your mental anguish and your nightmares and your fear. You can only get from the workman's compensation insurance company, not your employer. Some people tell me, I don't want to hurt my employer. I don't want to ask money from him. It's not him or her. It's their insurance company, the workman's compensation insurance. Go ahead.
I was going to say that's totally true. Many, many people feel that because they have an injury at work, they're going to be able to get the pain and suffering component of it, damages, or what we call non-economic damages.
Non-economic damages.
But every once in a while, for instance, we spoke earlier about employers who did not have insurance.
Yes.
If your employer didn't have insurance and you were injured, then
That's different, yes.
That's different.
Okay, thank you for clarifying. We're talking about those employers who did the right thing.
Right.
They have more than 2 employees, and they bought workman's compensation for the protection of their employees.
And
yeah.
And if the employer does something intentional to harm you, then you also have the right to emotional damages.
We are talking about, in workman's compensation, we're talking about incidents that happen through negligence or through nobody's fault. We're not talking about, you're right, workman's compensation does not cover intentional acts by your employer. That's very true. So if your employer means to harm you, then you can sue them for that. But if something just happened, an injury happened, then workman's compensation says you cannot sue your employer. Your employer followed the law by buying workman's compensation, and now here is what you can get. You can only get payment of your medical bills, and you can only get about 65 to 70% of your wages. And that is it. Am I correct?
Yes.
Nowhere in what I mentioned is there pain and suffering and anguish and fear and all of that.
And the spouse can't sue
the
for
wife,
the husband's...
Right.
Right.
In a car accident, if the wife suffers as a result of the husband, something happens to their relationship, it's called the loss of consortium. Sometimes we do. They're not easy to prove. They're very difficult. But you can. Here, the employee can only recover their medical bills, and the employee recovers 65 to 70% of their wages. That's it.
There's one more component.
Yes, please.
And actually, with the changing times and the changing law, this is actually a very important component. You're entitled to vocational training or placement. So if you can't do your former job, you can basically be, taught how to retool to do the next job, or you can actually have the assistance of a vocational counselor help you find the next position. And I mean, helping you with your resume, helping you identify the jobs that you could perform, and helping you in your interview skills as well, and finding jobs that are out there that she can place you in, or he can place you in.
So let's repeat that.
Sure.
When your employer did the right thing and bought workman's compensation insurance, and you are in a work-related injury, then your employer's insurance is responsible for 100% of your medical bills arising out of that injury.
That's right.
65 to 70% of your wages 1 month at a time. And if you're not able to return to the job you were in, you are also entitled from the workman's compensation insurance company for what's called vocational counseling.
Vocational services, vocational assistance, yes.
Vocational services.
Yes.
And that would means that the workman's compensation insurance company will assign a person who will talk to you about finding a job within your new disabilities and even help you fill out your resume and help you look for a job.
That's correct. It's
all paid for by the workman's compensation insurance company.
It's such an important component since 2011 because when they changed disability to basically mean an impairment in your wage earning capacity, you really had to expose yourself to the universe of jobs that you could do, to the universe of jobs you had done in the past. It's not enough any longer to not be able to do the job that you were doing when you were injured. Now you have to demonstrate by a preponderance of the evidence, by more evidence than the defendant has, that you can't not only do the job you were doing, but you can't do the jobs that you might have experience in for the last 15 years. And that's vital in proving a case, and you might as well utilize the services that the carrier is offering, that the insurance
carrier meaning the workman's compensation insurance company
is offering, because it's going to help you make a case if that's necessary.
Okay. A number of people think that an employer should wait for the employee to get better and cannot fill out that position. Is that true or is that false?
Well, that would be false.
That would be false.
Yes.
We are in an at-will state. An employer does not have to wait for you. Life has to continue. Business has to continue.
That's right.
Okay. So they don't need to take you back.
No, I didn't say that.
But do they need to accommodate you?
That's right.
Now, if they have, so let's explain what that means. So let me clarify. I'm feeling I'm starting to lose my steam here. If you are injured,
yes,
in a work-related injury, your employer does not have a duty to sit and wait for you to come back. Your employer can hire somebody else to fill your shoes.
This would be true.
However, when you get better and you're able to go back to work, your employer has one duty. And what is that duty?
Oh, well, if when you get better, he has the obligation to offer you what's called reasonable employment.
Okay, but what does that mean, though?
Okay, well, the first thing your employer is going to do is what the insurance company tells him to do. And the insurance company is going to tell him to find a job within the injured worker's restrictions that he can do. Because once he does that, the injured employee is obligated to accept that job if he can perform it. And if he doesn't accept that job that he can perform, then he's not going to get any benefits. So,
okay.
And that's called reasonable employment.
Okay. So let's say somebody hurts his back very, very bad on the factory line in GM. GM, once the employee gets better, his back is not good as new.
Right.
He may be still suffering from his back, but able to work in some sort. In the meanwhile, GM has offered that position to somebody else because they have to continue with business.
Right.
However, as soon as he gets better, good enough, the insurance company for GM, well, they happen to be self-funded, but forget that. The insurance company for the employer will say, we don't want to keep paying wages on this person. You, employer, find them a job within what they can now do.
Right.
This employee, for example, can no longer maybe carry heavy things or carry at all and so forth because of the new injury. So GM is required to look and see if they have any opening for something that they can use this employee for. Maybe a sit-down desk if he can, something else that accommodates and does not compromise his injuries.
Or aggravate it.
Right. However, if they can't find, sometimes employers cannot accommodate an employee with their new restrictions. then the employer is not required to dig and create a position, correct?
No, they're not. But they're going to be paying comp benefits until the employee finds a job.
Okay. So it is to the best interest of the employer to find accommodations for the employee, because if they can't find, they will continue paying workman's compensation.
I could tell you the story about the Gatorade man of East Jordan.
Well, tell me the story about the Gatorade man.
He was a burly guy.
Of East Jordan?
East Jordan, of course.
Jordan in the Middle East?
Oh, no, East Jordan, south of Petoskey.
East Jordan, south of Petoskey, Michigan.
Yes, they have an
gorgeous
ironworks.
Petoskey. Is Jordan east of Jordan? Is Jordan a pretty city or town?
I have to tell you, I've never found Jordan. There's just east of Jordan, and that's it.
Maybe Jordan doesn't even exist.
Right.
Please tell me the story of the Gatorade man who lives east of Jordan, south of Petoskey, Michigan.
Well, if you're ever walking in the street and you see a grid for the sewer system, if you see EJIW, that's East Jordan Ironworks.
Hold on. So you're looking at where the water and the sewage goes in the drain.
Yeah, and
you're looking for what initials?
Well, yeah, East Jordan Ironworks, so it would be EJIW.
Okay.
Yeah. And they're just all over the place. In any event,
I'm going to be looking for them the next time I see a...
You had this phenomenally strong, burly individual working at the ironworks and making these sewer covers and drain systems. And he seriously injured his back, and he could not do the lifting or the hauling he did. And rather than just...
Now, is that a true story?
This is a true story.
Okay, fine.
So he spent the last 20 years of his career at the ironworks making Gatorade for everybody.
Because the workers there needed to hydrate themselves.
Well,
so the employer at the ironworks found him an alternative job that doesn't use his back.
That's right.
Where he can be of service.
That's right.
And he spent the last 20 years making Gatorade.
Just stirring Gatorade.
I love that story.
Well,
because you know what? That story illustrates, how an employer can sometimes accommodate and how an employee sometimes have to settle for less than what they were trained for.
He was so
making
good at
Gatorade. That's the big burly man.
That's right.
Muscled up guy.
That's right. And they also allowed him to start giving out hard hats. So he would collect the hard hats at the end of the day.
What's with the hard hat?
Oh, well, the hard hat is just like a very hard hat you put on to protect your head.
To protect your head while you're working and welding, because this is all made out of iron or metal.
That's right.
All these sewer system drains.
There's a lot of danger in these plants.
So the next time I'm going to see there is a lot of danger on a worker safety is big in factories.
Foundries, sure.
And we take that for granted. We enjoy the hard work of these people, and we take it for granted. But truth is, a lot of people hurt themselves producing these goods that we enjoy.
It's guaranteed people are going to hurt themselves. It's actually taken into the equation, unfortunately, and that's how they determine insurance premiums for companies.
Right.
They know who's going to get hurt.
Right. And is it true that the next time I look at the drain, I will see the acronym EJIW, or is that your own?
Oh, no, I'm not making this up. Just look and you'll see.
East of Jordan Ironworks.
Yeah. It's right there. I mean, I shouldn't say it's right there.
And you've never been able to locate Jordan, Michigan.
No, there is no Jordan. There's just an East Jordan.
East Jordan.
There is a Jordan River in Michigan, though. I think that has something to do with it.
A Jordan River
It's
in
very
Michigan.
small in Charlevoix County.
And it's probably dried up by now?
I don't know. I don't know.
So how is it that you know that story about the Gatorade man out of East Jordan Ironworks?
Ironworks. Yeah, well, I guess when you work up in Petoskey for 18 years, it's a little bit like you've done your retirement first, and now I'm doomed to wear my wingtips for the rest of my short life, and I'll die in them. That's okay. I'm a happy person. Unfortunately, about Petoskey is every attorney who wants to retire has this idea in their head that they'll just go up, retire, and put their shingle out. Which means, some of your favorite taxi drivers will, you could talk to about your case, and they would know everything about it.
Why?
Well, because every other person's a lawyer up in Petoskey.
In Petoskey, because they want to practice law in luxury and in greenery and water, and they want to retire and practice law.
I don't know how many times you've gone ice fishing, but I wouldn't describe it as a luxury. So.
Well, but Petoskey is attractive to a lot of people.
It's a wonderful place.
And in the winter and the summer for sure, it's a gorgeous place to visit. It's about 3.5 hours away from here.
Yep, and it sits right off of Little Traverse Bay, which sits right off of Lake Michigan, and they have a saying, "View of the bay for half the pay." And believe me, it's true.
What does that even mean?
Well, it just means you're not really going to make a whole lot of money, position yourself in Petoskey. But
so what is it again that they say?
View of the bay for half the pay.
View of the bay,
yes.
the Petoskey Bay, the water,
right.
for half of the pay.
That's right.
So you want to enjoy the bay, but you're not going to make a lot of money as a lawyer, because there are a lot of lawyers up there.
Oh, no. You want to be a contractor. You want to build houses.
Wait a minute. You want to be a contractor and hopefully invoke the shoot-through provision.
Oh, that's right.
Not a general contractor. You're going to be sued as a general contractor.
That's right.
That's very funny. So let me ask you, how is it, on a serious note, I think that the story of the burly man who spent the last 20 years of his life, instead of welding iron and making drains for sewers, is serving Gatorade to his co-workers. Right. How is it that you came to know this story? Did you learn this in law school?
No. I've heard it.
You did not represent the Gatorade man, now did you?
No, I couldn't say that or not. Let's just say I've heard it in the annals of the halls of the Workers' Compensation Agency in Gaylord.
In Gaylord, Michigan, way up north.
Not as north as Petoskey, but it's up there. Oh, yeah.
I thought Gaylord is more north.
No, Gaylord's actually a little south of Petoskey, but it's more towards the center and elevated, so they get much worse snow.
And how recent is the case of the Gatorade man?
Oh, we're talking about probably the 90s. And things have gotten far worse these days in workers' compensation.
Such as?
Well, I'm just saying that, the definition of disability, when it goes from defining disability as not being able to do my last job to not being able to do, not having any job within the jobs I've performed for the last 15 or 20 years, that makes it much harder. Again, disability is defined as an impairment of your wage earning capacity. You can be disabled, and if you find a job which is paying you more than what you were making before your injury, you're not disabled.
Okay, what about if you are disabled from being on the factory line and now you are serving Gatorade, but it's a much lower pay? Is there a difference does the workman's compensation insurance pick up the difference between what you used to earn when you were welding metal and now serving Gatorade, so to speak? Of
course. They will make up the differential.
They, as in the workman's compensation insurance?
Well, the workers' compensation carrier, insurance company will make up the difference. And if the company is self-insured, which a lot of companies are beginning to do, then the company will shrug and say, well, we could either pay premiums and pay more money to the insurance company, or we could just continue his same rate and he'll be, making Gatorade instead of working on the line or in the foundry. If they don't have insurance. In fact, in 2020, we're going to see a new arrangement where there's entire groups of employers that are going without insurance, but they're grouping their risks together. So if you have an industry, let's say, where you're making car parts, or you have an industry where you're making residential housing, these companies can group together and take on the risks of injury as a group versus having to buy insurance policies. It's new. It's not in effect yet, but it's coming.
And that's as a way for employers to pay less money for workman's compensation.
Right.
So again, just focusing on the word disability. It used to be that disability, let's say, I am on this assembly line doing A, B, and C, and that was my job. If I was disabled from that, I used to be called disabled. Today, I pretty much have to be disabled from any job offered to me to be called disabled.
That's right. And it's a very rigorous test, which goes back
So
to
you're almost not disabled anymore because there is always the possibility of accommodating you in something that's needed.
Well, there must have been something just miraculous that happened in Michigan, because when they changed the definition of disability, there were like 40% less accidents. There were 40% less cases that dealt with work-related accidents simply by changing the definition.
Is it because people, figured that they have to just get on with their lives even if they are injured? Because
it's because the cases would be dismissed, because under the new definition of disability, there's always something you might have been able to do.
And so you're not disabled under that definition.
That's right. You're not disabled. And what's also interesting is part of the definition really places the burden on the employee, on the injured worker, to be looking for work in things that they could have done in the past. And if they
injured worker should be looking for work, or there is less of a need for the injured worker to be looking for work?
If you get to the end game, if you get to trial, the worker is going to have to prove that there's no job within his transferable skills, namely things he's done for the last 15 years, namely, what maybe he has been educated in, what training he's received. And the burden will be on him demonstrating all of that to show that he has no transferable skills to find a job that he can do.
And what about the last 15 years?
Well, I mean, if you're a disabled doctor, for some reason, and you were flipping burgers 15 years earlier, well, that's a job you can do. If you are at Walmart and you would be able to greet people, that's a job you can do. So, the onus is on the employee to really utilize the vocational services offered by the workers' compensation insurance company to demonstrate the nature of his transferable skills and what he can't and can do early.
Realistically speaking, I understand that one of the benefits that an injured workman's compensation employee can get is vocational counseling or services. How good are these services by workman's compensation insurance companies?
Yeah, here's the problem. Most attorneys, by the time the attorney is involved, the only involvement with the vocational counselor is as a matter of making evidence or establishing evidence as to what the employee can do. The time has gone by or passed where the vocational counselor can actually assist the injured employee in finding work. So is the quality of them good? Some are great, and some are very new and not so great. The concept only really began in 2011 when the legislature adopted a case called Stokes, and we call it Stokes proofs. So,
Stokes. Attorney Sam Safe talked about the Stokes interview in the immigration setting.
Oh, there you go. Well,
but that's not the same case.
I don't think it would be, although
the Stokes interview stands just for the proposition that married spouses can be separated during the interview by USCIS and placed in different rooms and questioned separately.
Oh no, a different
That's called
Stokes.
The Stokes interview.
Right. No, entirely different. Although there is a Stokes interview or Stokes evaluation.
Stokes evaluation, go figure.
In which the employer has a right to send his vocational expert to interview the injured employee to determine what the injured employee can still do. And then, of course, the plaintiff, the employee, should have their own vocational expert to rebut what the defendant's expert would say. But that seems like such a waste. I've always approached defense counsel, my brother and sister defense attorneys, and I've always said, why don't we find an expert we both like, spend the money on the single expert, and actually get a result that's beneficial to the employee?
Because you're going to have two very different vocational testimonies.
Right.
Does the vocational expert under the Stokes evaluation have the right to physically examine?
No.
Or just ask questions.
He or she will ask questions, but they will also be familiar with the employee's medical file in terms of his disability and restrictions.
Okay, but interview only and access to the medical records.
Right.
Okay.
And of course, they would want to see the employee's resume, but that's about it.
We have about 5 minutes remaining. Someone can be in a work-related injury and get SSD, correct?
Yes.
Someone can be in a work-related injury and get workman's comp and get SSI, right?
Well, if they're working, they may not qualify for SSI. Their income might be too high. Maybe.
But they may not have the credits.
That they may not have the credits.
So,
they may not have been working long enough. Or if you take their income and the entire household income, they might still qualify for SSI.
But just to clarify to our listeners that just because you are in a work-related injury does not mean you will automatically get SSD. You may end up getting SSI, because if you haven't been working long enough, if you haven't had the credits needed,
that's right,
you're not going to get SSD, but you have a disability, so you can get SSI. And in SSI, they're going to take into consideration the household income, not just your income. So technically speaking, an employee can be, a worker can be injured at age, let's say 44, and you really need 22 credits to get SSD, but maybe he has a work-related injury and he only has 20 credits. So he's gonna probably get SSI, not SSD. In other words, just to clarify that a workman's compensation injury can result to SSD if you have the credits.
Yes.
Can result to SSI, assuming that what you earn and the household income is within the SSI.
Yes.
Okay.
In fact, you could even get Social Security retirement. You could be receiving Social Security retirement by the time they're still paying your wage loss benefits out of a work-related injury. And then they can start actually lowering the amount of money that they're paying you because you're receiving retirement benefits.
Are you talking about those people who are 62 years or older?
Yeah, usually 65 or older, yes.
Okay. But when we're talking about a 25-year-old or a 45-year-old or a 55-year-old, we're not talking yet about early retirement. Early retirement is 62, retirement is 65.
Right.
You can get early retirement, but you will not get Medicare when you get early retirement.
That's my understanding,
right,
yes.
And mine as well. But you will get Medicare when you become,
65.
65.
Yep. And again, with the younger people being injured, there's no coordination between your Social Security disability and the money that the workers' compensation is going to pay you. In other words, you're not deducting.
Yes.
Right.
Now, that's a good question.
Sure.
Can you be obtaining workman's compensation money for 65-70% of your wages and at the same time qualify for SSD and get SSD payments from the Social Security Administration?
The answer is yes.
You can double dip. I can get 65% of my wages because I'm getting workman's comp and I have all the credits. I applied for SSD and I get another $1,000 from SSD. I can get from both sources.
My answer is yes. It's Social Security retirement where they can start to deduct dollar for dollar.
Not retirement.
Retirement.
We're talking Social Security disability.
Right. Disability, there is no coordination or deduction.
So you can double dip.
Well, let's think about it. The workers' compensation is insurance that is paid by your employer.
Right.
And the Social Security disability are
is what you're
premiums you paid
to,
on your own.
Right, because you paid money into the system.
Right.
So you've earned it.
Right.
Okay. So you can obtain both SSD and workman's comp or SSI and workman's comp.
Right.
Okay. Well, I thank you very much. It was a very, very helpful 1 hour. I absolutely adore and no doubt will reference repeatedly the Gatorade, the burly man who now serves Gatorade in the East Jordan Ironworks factory.
And again, in closing, all I would say is this is very, very detailed, complicated stuff. And hopefully, if we do anything, it's just to excite your imagination as to what may be available to you if you're an injured employee. And the consultation is free, and I wouldn't expect anybody to be able to navigate themselves around most of these laws. So please, if you have questions, we are available for you.
Thank you very much, Michael. Attorney Michael Roth, I really appreciate it. And Rami, thank you for being patient with us here. And thank you to all the listeners. My apologies. I did not do what I need to do, which is translate. But it is so very difficult. I think as I understand and I have a better grasp on this, I will be able to take a lot of information you share in English and succinctly condense it and translate it into Arabic. Thank you very much to all listeners, Rami and Attorney Michael Roth.